had another question about, now we're getting to the end of the process of the appeal. Let's say that the appellant obtains reversal of the judgment against him, and but the appellant had made some partial satisfaction, had paid some amount of the judgment along the way. So now the formerly prevailing plaintiff is liable to return all that partial satisfaction he had received on the judgment, and not only that, but full restitution as well, including interest and even lost business profits. That was a case we saw last year in Dr. Leeville LLC versus Westlake Healthcare. As I recall, in that case, it involved an eviction of a business from a building, and the tenant appealed the order. In the meantime, the landlord went and sold the building. Maybe didn't sell the building, but evicted the plaintiff, and the plaintiff evicted, the tenant. The tenant lost the business, and there was some $1 million in lost profits that I think nearly was awarded, or I think maybe it was left unsettled. But the upshot was that the formerly prevailing plaintiff may be liable for lost business profits if their former judgment is reversed. And I wondered if that sort of risk ever comes into your thinking when advising whether to go forward with enforcing a judgment.
Absolutely. We talked about debtors running into bankruptcy and the appellate court. And so if the debtor appeals, we want to know what's the likelihood that this is going to be overturned. And the creditor needs to know that if that happens, there's a good chance that you're going to be responsible for returning that money that we've paid out to you.
Yeah, better invest it with a good, better than 10% return.
So is it a good idea for the creditor to kind of once having recovered either part or all of the judgment, is it good to sit on it until the resolution of the appeal?
That's the recommendation that we make to clients. One of the strategies that we employ is the disentitlement doctrine. Oftentimes, again, people who have money don't want to pay, and so they will fraudulently transfer, they won't provide documents, they won't sit for examinations, they'll engage in obstructive litigation tactics. And we've brought a couple successful, and we have one pending right now, disentitlement motion to dismiss the appeal without reaching the merits. And so if our appellate standing isn't that great, an alternative is the disentitlement doctrine.
Yeah, that's a great tip. How egregious do the debtors' evasions need to be in order to kind of meet that threshold for dismissal under the disentitlement doctrine?
So like most cases, it says contempt is not required, but contempt would work.
Right.
And contempt is relatively easy to show. I mean, you can get contempt for not complying with a subpoena, not appearing at a court-ordered debtor examination. That's a court order to appear, and you are in violation of that court order. Typically, for us, it's obstructive litigation tactics. It's a pattern of continually taking actions to disrupt, hinder, delay, and defraud the creditor.
Is that an active strategy in some of your cases to kind of check those boxes to see if you can satisfy the elements of a disentitlement motion?
Absolutely. So again, from the beginning of the case, we're thinking appeal. What are the merits of our appeal? Are we in a strong position? But at the same time, are they shooting themselves in the foot by opening themselves up to be dismissed before they reach the merits?
That's I think that's a great tip. I love bringing disentitlement motions when they're justified. I think in the last year or so, Jeff, in the cases, I think both of us are always looking out for opinions that dismiss appeals on disentitlement grounds. It seems to be getting, at least from my eyes, it seemed to be getting a little bit harder to meet the standard for disentitlement. I wondered if that met with your experience, Joseph. Are Are they harder to achieve than they used to, dismissals on disentitlement grounds?
I'll be honest. I think we're at a total of 4 that we've done. So I don't have a tremendous amount of experience. But no, I don't find them any more difficult. That being said, the debtors that we deal with are the worst of the worst. They're the 1% that when you hear the facts, you're like, oh my God, why isn't this person in jail?
You have just listened to the California Appellant Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.